Of the settlement conferences in 87 matters, 27 matters were settled or partially settled, and 35 were not settled, giving a settlement rate of 31%, which is somewhat disappointing. But I understand that there were reasons sometimes why matters were not settled. For example, there was a report outstanding. The attorneys didn't turn up, even though they agreed to turn up, and such other reasons that some make sense and some don't. But what can I say? Was the process helpful? 100% of the parties in the sample found the conference to be very useful or somewhat useful in 1, clarifying or narrowing the issues of liability, 2, clarifying or narrowing the monetary issues, and thirdly, encouraging the parties to be more realistic about their respective positions. 100% of the parties also found the conference to be very useful or somewhat useful in improving communication between the attorneys, improving the parties towards eliminating certain issues in the case, narrowing the gap, and encouraging the parties to be involved in the resolution of the case, which sometimes doesn't happen because they're sitting down listening to the lawyers talking about how complex it is and why it should take more longer. All meant to be said sotto voce. So 90% of the attorneys in the sample found the conference to be very useful or somewhat useful in clarifying or narrowing the issues of liability, clarifying the monetary issues, and encouraging the parties to be more realistic. From a judge's point of view, 83% of the judicial officers found that the settlement conferences were a useful tool in effecting settlements of matters in their dockets. And I just mentioned to you that notwithstanding the fact that the pilot project has come to an end, that's still going on. You will get an email saying, I have this matter, is anybody willing to do a settlement conference? And within a matter of hours, someone of us volunteers to take a settlement conference from another presiding judge. And so we are continuing to do settlement conferences on an ongoing basis. We are not waiting for the implementation of court annexed mediation. It's still going on. In terms of the rating of the settlement officer's performance, 100% of the parties rated their settlement officers excellent or good, and 100% of the attorneys rated their settlement officers as excellent or good in 3 of the 10 skills for which they were evaluated, and more than 90% of the attorneys rated their settlement officers excellent or good in the other 7 skills. And 97% of the parties in the sample indicated that they would try settlement conferencing again. In fact, it's becoming quite a demand upon those who are willing to volunteer. Some of the comments that were made by the parties, I'll just read you 1 or 2. It helped to clarify the positions where the claimant and the defendant were. The conference assisted mainly in the identification of the strengths and weaknesses of both parties' cases, and the conference helped us to see the long-term benefits and explore the bigger picture. The attorneys, 100% of the attorneys indicated that they would engage in settlement conferencing again. And some of the responses from the attorneys was the judge's approach was tremendous. I'm confident his input and suggestions helped to resolve a matter that was near impossible to settle prior to the GSC. Overall, the GSC opened previously closed doors of communication. So the combined performance, the total number of matters in which mediation or settlement conference was conducted, 267. The total number of matters settled and partially settled was 147. So it means that 55% of the matters were resolved or partially resolved without the need for a trial, thus saving the parties time and money. Now, I suppose if you sat SEA or CXC and you got 55%, you might say, well, you know, that's a bare pass. But if 55% of my docket was reduced as a result of mediation and settlement conferencing, I'll be kicking my heels at the fact that I now have some time to write my outstanding judgments. So let's look at the recommendations of our consultant. Mediation and settlement conferences should be implemented in the civil litigation system in 2015, and as I've told you, the Chief Justice has approved of this recommendation, all of these direct recommendations. The practice direction which was used to regulate the pilot project should be given the force of a rule of court. So that is in hand with the Rules Committee, and Justice Pemberton is here to verify in case you don't want to take it from me. Attendance at mediation should be mandatory, and I know we are following in good footsteps, because you heard that in Canada it is mandatory, and I know from my conversations with Mr. John Massey that it is also mandatory in Jamaica. So we are finally going to be catching up with the world and not lost in this abyss of litigation till the death. And as we know, as litigators and as judges, sometimes that's quite literal. Either the death of the judge, or the death of the parties, or the death of the attorney. Another recommendation that has been made is that there will be an ADR judge who will hear applications from those who don't wish to go to mediation or don't wish to go to settlement conferences, and complaints of non-compliance under the proposed ADR rule. And that ADR judge will be a full-time settlement officer. And an important recommendation is that the judiciary should initiate discussions, or more correctly, continue discussions with the Law Association of Trinidad and Tobago and the Hugh Wooding Law School. Ms. Yearwood was here yesterday, to ensure that attorneys are educated, because that's part of the challenge, educating the attorneys of their role in mediation and in settlement conferencing. Some of them don't quite get it yet. So there is a need for education throughout the system. So now I come to the question of gratitude. I want to express my gratitude to the Chief Justice for embracing the idea that we had to do this. Otherwise we would drown. We are barely coping with the volume that we have. And this is a breath of fresh air in the judiciary. The project committee, which I had the honor to chair, worked very long and hard. We met regularly. We had representatives from the AG's department, from the Minister of Legal Affairs. We had many internal stakeholders, the persons from the statistics department. Justice Kokoram and Justice Pemberton were my sounding boards on every step and gave me a lot of guidance, because you know, they are in the forefront of the mediation movement, and I am grateful to them. The mediators took this very seriously, and you know, they knew that how they performed would encourage the parties and the attorneys to embrace this. And therefore, I want to thank all the mediators, some of them who are here. I have seen Mr. Otway, I've seen Mr. Mendez, I've seen many other of the mediators here, and I want to personally thank them for the effort that they made to ensure that these percentages that I've shared with you were accomplished. The Dispute Resolution Center also, as the selected agency, pull out all stops. Beverly Britton is here. I reminded her today, please don't miss today, because I may want to call your name. I don't think she knew that part, but anyway, That's the reason I told you, Beverly, that you need to be here. And the other members of the board who are here, I'm grateful, the judiciary is very grateful for the effort that the DRC made in ensuring the success of this project. All the attorneys, I know my good colleague, Mr. Joseph Tony, is a convert and his daughter is here, to mediation. So we need people like that, seniors in the profession, to embrace it. Also, all the parties who willingly participated and who came there with a desire and intention to settle. So what's left for me to say is that I am enthusiastically optimistic that all of that I am telling you today, I will not find myself in any embarrassing position next year when they have this symposium and I have to say, well, it wasn't done. My expectation, being realistic, is that by September of 2015, in the start of the new court year, we would have court-annexed mediation of all the matters coming through the system, and I'm going to be working tirelessly to accomplish that. I know from the Jamaican experience and the Canadian experience that this is the way we need to go, and I want to thank everybody who has made it all possible. Thank you very much.
Thank you very much, Justice Devines. I think for those very insightful remarks and statistics, I should mention that among our gathering is, I would say, a group of students, postgraduate students from the University of the West Indies, who are looking at the subject of civil procedure for mediators, so that I hope that they've taken careful note of what has been shared, and particularly the statistics that have been mentioned. We also have groups of other attorneys present here who are, I think, perhaps now on board with the mediation process, particularly from the revenue authorities. So we've really heard some very helpful remarks on court-annexed mediation. We move on now to looking at other relevant aspects of the justice system, particularly on the criminal justice side. And here to discuss with us the work of the Drug Treatment Court and the first graduates are two very distinguished presenters, Justice Holdip and Mr. Roger Gaspard, Senior Counsel. Justice Holdip has been a High Court judge for the past 13 years in both the criminal and family divisions. He is a graduate of the University of the West Indies, having obtained his LLB in 1979 and his legal education certificate in 1981. His academic achievement also includes a postgraduate diploma in public administration, a master's in history, and he's currently pursuing a master's in criminology and criminal justice, though I don't know where he would find the time to do all of that. It's rather impressive. Justice Holdip is a certified mediator as well and sits as the chair of the steering committee of the Drug Treatment Court, in addition to overseeing the Bail Boys Review Court, an initiative, as you know, that really had its genesis from the work of our distinguished President of the Republic, Justice Carmona, His Excellency Justice Carmona. He's been a tutor in trial advocacy at the Hewarding Law School since 2004, and his hobbies include steel band, calypso, and carnival research. He served as the chairperson of the Calypso Adjudication Committee from 2009 to 2014. Justice Holder.
Thank you very much, Mr. Chairman. Good morning to all the participants and the persons who are attending this conference, including the Chief Justice of Rwanda and our judge from the Caribbean Court of Justice, Mr. Adrian Saunders, Justice Saunders, and all the other justices, magistrates, registrars that are present. The task before me this morning, more or less to harmonize with my brother, Mr. Gaspard, some of the workings of the Drug Treatment Court. What I will do is go to our brochure published in 2014, our frequently asked questions, and from that step off into the whole idea of the Drug Treatment Court. Drug treatment courts have been introduced in Trinidad and Tobago at 2 locations, San Fernando and Tunapuna. These courts have evolved out of a proposal by the Honorable the Chief Justice arising out of concerns over the number of persons brought before the courts on drug-related offenses. The courts provide an opportunity to address in a more effective manner the disease of substance abuse among nonviolent offenders while reducing the recurrence of persons relapsing into a life of crime. Fundamentally, therefore, that is what the drug treatment court is. It is a new process introduced into Trinidad and Tobago after approximately about 2 years of preparation. It was introduced in February 2013. And since then, we are proud to say that we have been able to have 5 graduates in July of this year. The court in San Fernando has seen 30